So, Stephen, how are you today?
Good, thanks. How are you?
Great, thanks. So, New Year is coming, huh?
Yeah, but New Year is coming, but also still see some nightmare.
M&A transactions are arising after the COVID lockdown. So I see that you are a very experienced lawyer in labor issues. So I think that your labor expertise can help the clients in safeguard the labor issues in the M&A transactions. So can you share a bit about your experience?
I think that's in the. Let me talk about only the most critical point, not about the issue, because it's more about the business and people. And then when there is the problem between the people, it will arise, become the legal issue. So in my experience with the M&A, the labor issue in the M&A transaction, that's the cultural conflict. I experienced many situations already. The employees from the acquired company, they move to the acquiring company. And there is the psychology issue. Like you already have you already acquainted with the boss, the culture of the acquired company, and now you move into the new environment with the new culture, and you have to make friends with the new the employees in the acquiring companies.
And also the employer.
Yeah, also the employer, the new employer, and there is some conflict between the people. You can see that they feel. I think that in the new employer they are, because I am also acting for the new employer acquiring company in some situation, they are quite fair and pay the generous amount to the employee.
Yeah.
But many psychology issue in the employee of the acquired company arise. For example, they feel that they are looked down because they are under the supervision of or the management of the new manager of the new employer, and sometimes they feel that their talent is not put in the right place. But honestly, they do the same job as what they did before in the acquired company. It's just about a psychology issue, and when that psychology happens, there are many small issue, small conflict in communication, in the cooperation with the new managers, new directors. And of course, when you come to the new environment, you come to the new employer, you must to follow their culture. You have to adapt yourself to the new culture and improve yourself and survive through the conflict so that you can have a better understanding of how the new employer and have a good cooperation with the new director or managers. So when the both side don't have a good cooperation, there's we call this the cultural conflict, and it's become and cultural conflict is more the human resources issue, because if there is a conflict in the working place, it will affecting other people or affecting the working environment as well. So the only way to stop it is you have to say goodbye to the employee.
But I don't think that it's like saying goodbye to the employee is not easy in Vietnam, right?
Yeah, not easy. That's the reason why, as a experienced lawyer, when you're preparing the document for moving the employee of the acquired company to the new company, acquiring company, if you have you have experience, you have much experience, you know the risk already. You will know how to structure the legal clause, legal provision in the transition document to protect the new company, the acquiring company, wasn't fair to the employee of the acquired company. So and of course that legal tactic will saving the cost for the acquiring company in scale of labor dispute, and also protect the acquiring company from any legal risk, because the legal the labor document transition document in M&A is not simple like you sign the new contract with the employee, with the new employee. In the new, you must have some paper, some special legal provision, really say about the situation, about the responsibility and the circumstances. You have the right to terminate the contract, and of course, it's in the acceptable terms and fair to the party.
That's wonderful to know. So you have explained to us about providing some clauses that will protect the acquiring company, also the target against the target company in the transition documents. So what are the legal issues or legal matters that usually arise and in the labor area, and what is the solution to those matters?
Honestly, in the common way, negotiation between the party also the best solution. If the party can reach the amicable solution, that's good. Because I believe that in the culture of the global corporation, they want to have the mutual agreement and mutual consent in peace with the employee rather than fighting at the cost, because fighting at the cost is very costly and taking time and tired to the parties. But sometimes we see some employee, they don't understand, and they claim the unreasonable compensation to the company, and they list many demands as if he's the boss of the company. So in that situation, I think that to protect the company, we must have if we can, we do the best, and we cannot negotiate anymore to reach the acceptable compensation. So we should have another way to terminate the employees. And the good lawyer should focus on that point, prepare for that situation as well.
So if I am like the seller, I'm like a buyer. Like I want to approach a company to acquire shares in the company. What are the labor issues that I have to look into before I decide to buy shares in the company?
The critical labor issue, if you are the buyer, you want to look at is I think that you should have because on the legal techniques, it's about you should check if there is any labor dispute ongoing of the acquired company with the current employees, and how's about the labor contract regulation between the acquired company and its employee. Because if they have the very simple contract and all the standard labor contract template, you should revise carefully. And for example, if you are in the M&A and you discover there is a labor dispute, and the labor dispute costs around $3 million USD because the dispute is with the high rank position, so you can use the leverage to negotiation about the price in the M&A, because when you acquire the company, it means that you acquire the risk as well. Yeah, and the labor contract with the current employees, if it's so simple and so standard, the common standard, it cannot protect the company. So you need to consider what's your business culture and how to protect that business culture when the employee of the acquired company move to your new environment. And based on your business culture, you will supplement and improve the labor contract transition document during that process.
So we mainly look at the labor contracts.
Yes.
So what are the labor documents that we need to look into?
The labor document, I think that that's the key. The key point is the labor contract. I know that also in all the labor document like the internal labor regulation, collective bargaining agreement, but honestly, they are not critical like the labor contract.
So if like in case a target company is like hiring many foreign employees, do I need to look into something about that case?
You look at the work permit because they established the relationship with a foreign employee. You must have the work permit. Without the work permit, the employment relationship is invalid under Vietnamese law. Yeah.
Okay.
Yeah.
So I think in sum, I need to look at the labor contracts and also the work permits if there are any foreign employees in the target company. So these are the two key issues that I need to look into.
Of course, I believe that in many global corporations, they are strictly compliant with the law. So the work permit is obvious. And when you're recruiting the foreign employees, so there must be work permit. And if there's no work permit, they will not sign the labor contract with that employee.
Okay.
So I think the most important is still the labor contract because from the labor contract you can discover all the issue.
Okay. So one more question before we finish this. So I see that the new labor code provides that in case there is like service contracts that are similar to the labor contracts that may be risky for the employer, but I don't quite understand that concept. So I don't see can you clarify the risks and also the situation?
Under the new labor law, the service contract with individual is not allowed for sure. So the employer can only sign the labor contract with the employee. And I know that there's some company, they want to use the service contract for the based on the civil court of Vietnam. But based on the civil court of Vietnam, we must refer to the commercial law as well. And if you want to enter into the service contract, you must register the business with the authority because service contract is mean the commercial. And if you register the business with the authority, and then you have to issue the invoice for the service you provide to the company. But if an individual register the business, it's not necessary here because the cost to maintain the business, like the accountant, issuing invoice, and other things like a company. So, but only for an employee service, an individual service, I think that's unreasonable. The civil law only allow for some small service like the fixing car, fixing a house, and something like that. But for the service like the accountant service, lawyer service, you must have to register your business with the licensing authority as well.
So now if I purchase a company, I need to look for service signed with individuals also.
Yeah.
Okay, that's very interesting to know. Thank you, Stephen, for a very interesting conversation with me about the labor issues in M&A transactions. So thank you very much.